Very good. Well, good afternoon, everyone. Hope everyone is doing well. Today is Tuesday in May. It's not Tuesday. Today is a Thursday in May. And we're so glad you're all here. So today we're going to be going on with our series on webinars and with questions about many legal questions. And we have Jay Bell with Law for Small Business. And the topic of like got sued, now what to do as a business owner. So again, all of these recordings of the webinars will be on our YouTube channel, so you can just Google New Mexico Minority Business Development Agency. It will be posted within 24 hours, and all of the other webinars also related to legal questions are also there. Well, very well. I will pass it along for Jay to share his screen and start the presentation. Thank you, everyone.
All right. Thank you very much. Hopefully you can see my screen at this point. Gabriella, is that?
Can you share it again?
Pardon me?
If you can share again.
Oh, okay.
Perfect. We can see it.
Perfect. All right, great. Thanks, Gabriella. Again, my name is Jay Bell. I'm an attorney with Law for Small Business in Albuquerque and Santa Fe. And so I kind of titled this Lawsuits 101. I'm going to start off with some things that, a lot of you may know, but I thought it'd be a good idea to start ground zero just to make sure everybody's on the same page. So we'll be talking about, have you been sued? Now what do you do? And that kind of thing. And maybe we'll get into also some things that you might be able to kind of put into your business as some processes to alleviate the risk, or at least minimize the risk of getting sued in your business. So just a couple of disclaimers up front. I'm not giving legal advice today. It's more of an informational seminar. We're not creating an attorney-client relationship today. We'd love to do that with you at another time, but just want to make sure everybody knows that as far as today goes. So a little bit about myself. I'm been practicing law for a little over 30 years now. From the very beginning, I joined a firm that specialized in business law, so both litigation, with lawsuits and such, and also business transactions, putting together leases and contracts and purchase and sale agreements, buy-sell agreements, those kinds of things. All the kind of the legal bundle that comes with owning a business. And I'm licensed in 3 states: California, New Mexico, and Georgia. So those are the 3 states that I've practiced in currently in New Mexico. So let's, kind of get started off at ground zero and what exactly is a lawsuit. I mean, you probably all know, hopefully not through personal experience, but it's a court process, and there's a side process that goes along with lawsuits that's not in court. That's called arbitration. You may have heard about that. We're not going to really delve into that, but it's very similar to just being in court as a result of a lawsuit. So the person bringing the lawsuit is typically called the plaintiff, and that is the party or the entity or the individual that's seeking to assert some kind of right against someone else, and that someone else is called the defendant in a lawsuit. And the plaintiff is trying to do that through the use of, a government agency, and that would be the court. And there, it results from a dispute over generally lots of different things that can come up in a business transaction. From a business to a customer situation, where if somebody slips and falls, in the grocery store, to 2 parties that enter into a contract with each other, and at least one party believes that the other party is somewhat breached that contract. So it's a myriad of things that can come up that causes this dispute. And it's usually about money. Occasionally, someone seeks the help of the court to force someone to do something that's different than just handing over money. But that's sort of a side issue. About 90% of the time, the disputes come up about money. Somebody owes somebody else money, or at least they believe that someone owes them money. And those are pretty much called legal claims in court because it's monetary. The other one that I mentioned, when you try to use the court to get an order ordering someone to do something or not to do something, that's in an area called equitable relief. And that's not necessarily money. It's actually getting someone to stop doing something or get them to do something. And you've heard of possibly temporary restraining orders, or you're going to get an injunction against someone to stop somebody from doing something. That's the other kind of relief that people seek in court. So you have money, and then you have this equitable side, which is order someone to do something or order them to stop doing something. And 99% of lawsuits are really right in those two different areas. Now, when a defendant gets sued, when someone gets sued, that person may also have what are called counterclaims against the person that's suing them, right? So let's say there's a construction contract and the construction company is not getting paid. So the construction company sues the homeowner and says, well, you breached the contract, you didn't pay me my money. And the homeowner is then the defendant. And the defendant says, well, wait a minute, you built a wall in my house and it wasn't right. So I'm going to countersue you in my counterclaim for money that it costs me to rebuild that wall. So even though someone's a plaintiff and someone's a defendant, there could be claims going back and forth. So at the very beginning of a lawsuit, someone might be identified as a defendant, and they will be the defendant throughout, but they also will take on the role of a counter plaintiff, where they have claims against the plaintiff himself. So, I touched on this a little bit. The types of claims that appear in lawsuits, it could be just 100 different things, but the main categories of claims and lawsuits are breach of contract. There was a promise, somebody promised to do something, whether it's build a good wall or to pay a certain amount of money for the purchase of a product. There are promises made back and forth between the two people that are involved in the contract. I promise to pay you, you promise to deliver something to me, that kind of thing. And that can be verbal and it can be written. So it's interesting to me, even after this many years, that occasionally I'll talk to new clients and they'll say, well, I know I had it was an oral agreement. I know they're not enforceable. And I'll say, I'll ask them, well, why do you say that? Well, I just heard that everything has to be in writing. That's not true. An oral agreement or an oral contract is just as enforceable as a written contract. The difference is the oral contract is harder to prove, right? Because it's oral. So somebody takes the position, well, you agreed to do this for this amount of money, and the other person says, I never agreed to that. Or I agreed to pay you, but not that much money. So then it becomes, sort of a he said, she said. That doesn't mean it's not enforceable, but it makes it more difficult to prove. And so that's why, you really want to have things in writing. And it's one of those things where if there is no signed contract, sometimes you can bring in other documents to sort of explain to the court, well, this shows what the terms were. Maybe there's a couple of emails back and forth, or a text or something that can shine some light on what was agreed to, so that the court has something to look at. It doesn't mean it's a written contract, but it does show some evidence of it. And we'll talk more about writing things down and keeping good records and that kind of thing. And that's how it ties into the whole breach of contract situation. Fraud is a claim that often shows up in civil litigation between businesses. It's difficult to prove because you have to, as one of the elements of proving fraud, you have to show that someone in this fraudulent conduct that you're alleging was intentional. And it's difficult to show that because you basically have to show what was in someone's mind at the time. Now, if there's a written document that someone explains or expresses their fraudulent conduct, well, that's another thing, but rarely does that ever happen, right? So if somebody says, well, you knew you weren't a good builder, but you told me you were a good builder, and I relied on that representation that you made, and you knew it wasn't true because you've never built anything before in your life, that could be an example of how you could show fraud. Negligence is a very common claim made in civil litigation between businesses. I didn't intend to do something in a poor fashion, but I should have done it in a better fashion because of who I am or what my experience was. I was negligent. I forgot to check this, or I wired something incorrectly and I didn't catch it. It's not an intentional harm, but you were negligent. A grocery store could negligently leave, spilled olive oil all over the floor. They should have cleaned it up. They left it there for 3 hours and someone slipped on it and injured themselves. So all kinds of different scenarios can pop up that fall into the whole negligence category. And then, a typical thing, somebody purchases products or services and then they fail to pay for them. And then maybe you run up an account with someone, with one of your customers. They don't pay you for whatever reason. Maybe their business is going south, or they just decided they didn't want to pay you. So there's that whole category of lawsuits that are brought based on accounts. You owe us money for whatever reason, and you're refusing to pay, so we're going to file a lawsuit against you to get our money. But in all of these instances, we call it a failure of a legal duty. You had a legal duty to do something as a result of whatever the relationship is between you and the person who you're sideways with, whether it's a contractual duty or whether it's just a reasonable duty to behave in a certain way or to perform services in a certain way. It's an alleged failure. It always starts off being, an allegation. Someone files a lawsuit and says, we believe that you were negligent, or we believe that you breached this contract, and you had a legal duty to do a certain thing and you didn't do it. So, some of those examples that come up in business, you have a lease. And when there's a lease between a landlord and a tenant, there are obligations going back and forth. Landlords have certain obligations to, provide a safe space, and to possibly pay the utilities, depending on what the lease says, keep the roof in good shape so that water doesn't, fall down into your business. The landlord has certain obligations, and possibly one of those obligations, there's a failure. The roof leaked, he didn't get it fixed for a year, for example. Tenants have obligations to pay the rent, to maintain insurance, possibly on their equipment and the contents within. They have a lot obligation to not, build an open fire inside the space. There's obligations going back and forth between landlords and tenants, and sometimes those get sideways because someone believes that the other has not lived up to their legal duty. There's a lot of this in construction cases, whether it's commercial construction or residential construction, and a lot of moving parts. You have, maybe delays that are going on in the construction. Possibly the contract provides for delays due to weather or unavailability of materials and those kinds of things. So it can get complicated as to,
Hello? I know that he's frozen for me. I don't know if he's frozen for anybody else. I don't know attendees.
Yeah, for me too. Yeah.
Okay, I wonder. Hopefully it will come back. His frozenness. I apologize, attendees. Not really sure what's happening there. Hello, hello. Oh. I'm so sorry, attendees. I'm hoping he'll log back in just a minute, and then he can share his presentation again. I wonder if it's related to the weather here in Albuquerque. That's been a little crazy today, and maybe his Wi-Fi logged out. I appreciate understanding and patience. Meanwhile, actually, what I'll do is I will just show everyone until he comes back our YouTube page. So if anyone can Google the Mexico Minority Business Development Agency YouTube channel, this is what you will come up with. And the reason I want to show up is because all of our webinars are recorded in there. So for example, last week we had another one about law, understanding unemployment law compliance. We had one about HR, about strategies for organizational culture, employee engagement. So you can just click videos, and all of the 40+ videos are listed here. ChatGPT, legal issues to consider, about grocery receipt tax and doing business online, business partnerships, how to handle it, bookkeeping, Corporate Transparency Act. This is a very important one that's necessary for all businesses. How to do work with the film industry. So feel free to just scroll around and see if there's anything interesting, and feel free to watch it, and you can pause it. So that is just like a good resource, and including this webinar will also be listed on the YouTube channel. I don't know if there's any questions from the webinar participants. Feel free to add it to the chat. I apologize. I'm hoping that Jay can log in just a minute. Do you have anything to share, Sophia?
No, just a reminder for our professional services that we offer. If you wanna talk about that a little bit, and I will try to reach out to Jay to see what is happening.
Okay, sounds great. Yes, let me actually share a screen about our professional services. So, great reminder. So, in addition to all the webinars, we have all of these services still available. So, if a business wants 2 hours of accounting, one-on-one consulting, the accountant can review your books and support for 2 hours. This is available. We also have graphic design services to create a logo or a business card design. We have videographers ready for the 90-second promotional video. Social media marketing, helping with social media accounts and posts. We also have proposal writing. So if you need one-on-one support to respond to a bid at city level, federal level, state level, let us know, even private. We can connect you with someone that can support you with 4 hours to support you with that. And then even HR consulting related to, anything related to employee services. So I see that they are back. Hey Jay, let me make you a co-host. That way you can share your screen. Hello? I see you're muted.
There I am.
You're back.
I'm back. I don't know what happened. Was it on my end or yours?
On your end, yeah, we
Oh.
stayed there. You froze for a second and then you logged out. Maybe it was just the internet.
Yeah, I couldn't get back in there. So I logged out to try to get back in, but okay, so.
You want to share your screen? Hello? I think it's happening again. Gloria, I see that you're one of the attendees. Could you just put in the chat if you're also having trouble with Jay? Like he is frozen on my end. I wonder if it's for everyone or just for me. Or any of the attendees can also do that. Is he frozen again, Sophia, for you?
Yeah.
Hmm. Yeah, hopefully he will log in. Okay, so Gloria, you can see that he's frozen, yes? Okay, that's good. Okay.
Back. I think I'm back, but I don't know what's going on. So.
Yeah, you keep freezing and then logging out. You want to try again, you're a co-host, so you can share the screen.
All right. Let me see if I can get this going. Okay. There, we're still there.
Yes, we see it. Okay, go ahead.
Okay, sorry about that, everyone. Okay, so getting on to the
Yeah, it's happening again.
Yeah.
Maybe if you try to don't use your video and just sharing your screen.
Yeah, but my guess is when it's frozen like this, then he'll log out. I can't even close his video for him because it's frozen. Oh. Hey Jay, if you want to, yeah,
hello.
if you want.
All right, we'll try it again. All right, can you hear me, Gabriella?
Yep, I can hear you. Yeah.
Okay, we'll just leave it the way it is. I'm not sure my.
Hi, everyone. I can't hear Jay. Hello?
Yeah, I can, it's again, froze.
I'm so sorry, everyone. Just hoping that I think it's the rain and access to the internet that's happening. That's the issue.
Okay, I think I'm back again.
Yep, you're back.
Okay. I don't know. It says I'm connected, but it's for some reason I keep losing it. But
Yeah, I don't know, but maybe it's something with the Wi-Fi. But go ahead and try sharing your screen again.
all right. So
There you go.
okay. So when you have when your company is an LLC or a corporation, the law requires that entity to have a registered agent. And a registered agent is someone who is available to receive service of process on behalf of the company. Doesn't have to be a lawyer, it can be anybody. A lot of times, owners of businesses put themselves down as registered agents. The problem with that is if you are the registered agent, you have to put your address down, which tells everyone where you live. And then the process server or the sheriff might show up at your house at dinner time and serve you with a lawsuit in front of your family, which is not a good thing. So there are national companies, local companies that act as registered agents. They may or may not be lawyers, but you have to pick someone to be the registered agent. One of the good things about having a lawyer be the registered agent is the lawyer knows what has to happen within the deadlines that are associated with the lawsuit. When you're served with a lawsuit, you have to file an answer within 30 days. And the 30 days starts to run from the date that the registered agent was served. So if the registered agent receives this lawsuit and sits on it for 28 days and then says, oh, I need to call the owner of this business and let them know, you may be up against a deadline quickly. Attorneys realize this, and so attorneys will get the papers to the owner right away, and they can start working on it. If you don't file a timely response to a lawsuit, a default judgment could be entered against your company, which is is really bad because a default judgment is issued by the court, and basically all the allegations in the lawsuit are deemed true. So the court, as far as the court's concerned, they will have decided that whatever the person suing you for is accurate, and that a judgment is entered in against you. There's some processes you can engage in to undo that, but it's expensive and timely. So you want to avoid that. So you get a lawsuit, you have 30 days to file a response, and you go through the lawsuit or each one of the allegations, and you have to either say yes, that's true, or no, that's not true, or I don't know what this person's talking about. But you have to go through and address all the allegations. And you may have what's called affirmative defenses, where you may have heard of the statute of limitations. You have to bring certain lawsuits within a certain amount of time, or they are meritless and you can't bring them. So you allege those things, you respond to the lawsuit, and then you bring whatever defenses you have. And if you have a counterclaim, as I talked about earlier, you have to bring that at the same time as you file your response or your answer. And if you do file a counterclaim, then the plaintiff, the one that brought the lawsuit in the first place, has to respond to your counterclaim. So there's a lot that goes into responding to a lawsuit. And so obviously, we recommend that whenever you're sued, you get a lawyer to represent you, because, a typical layman or person doesn't really understand all the ins and outs of a lawsuit. Interestingly, in most states, if you're an LLC or a corporation, you have to have a lawyer in court. The president of the company cannot go into court and say, I'm representing the company. This basically would be a representing or practicing law without a license if you did that. So if you have an LLC corporation, you have to have a lawyer anyway. So you might as well start off with one at the very beginning. And the law changes. So you want to have somebody that spends their life dealing with the law. One of the things that's come up lately is the Federal Trade Commission has issued a ruling that non-compete agreements aren't going to be enforced anymore. And there's some ins and outs of that. So you should talk with a lawyer about any non-competes, either that you are subject to or that you have required your employees to sign, because the law is changing on the non-compete landscape as well. So you have a lawsuit filed, you have filed an answer, and then you enter into this discovery period, which is a period of time where both sides to a lawsuit are able to discover what the other side's case is all about. What documents do you have? And you can send questions, and those are called interrogatories. You can send written questions to the other side, and they have to respond to them under oath. You can request the documents, and it works much like a subpoena. You don't actually have to issue a subpoena. When you're engaged in a lawsuit, you're obligated to provide discovery and send documents that are requested by the other side. And you can do that with non-parties to a lawsuit. Let's say it's just between two people, the lawsuit, and there are other parties that were involved in the transaction, but they haven't been sued and they're not suing. You can get information from those third parties as well through this process. So that's kind of the written discovery side of it. Then you may have heard the word deposition. You can take depositions of people. It's somebody who's under oath, and lawyers can ask the parties questions. And if you are, in fact, the person that is suing, the defendant's lawyer can take your deposition as well. And you can take depositions of non-parties. Maybe there was a witness to something. You can put that person under oath and ask them questions. So you can see, once you get the lawsuit filed and it's responded to, then you enter into this time period where a lot of time goes by and it's expensive. Because every time a lawyer is sitting, in a room working on your case or defending you in a case, there's an expense that goes along with that, and it can get pricey. One of the things that happens in a lawsuit as well, occasionally, is someone says, well, I'm going to file a summary judgment motion. And what's that? Well, it's a situation where you could go to the judge, you file some paperwork, and you say, Judge, some of these facts surrounding this dispute are he said, she said, maybe they're in dispute a little bit. But the facts that really matter here are not in dispute, and here they are. And you lay them out. And you say, this is a situation where we should win right now with not having a trial. And so that's called a summary judgment motion. And the other side gets an opportunity to oppose it and present contrary evidence. But again, what's happening here is time's going by and money's being spent by both parties. in going through this process, and it takes a while. I remember the last time I practiced law in California, it was 3 to 5 years before you could get a trial on a case. The courts were so backed up, and that was a while ago. So it can take you a while. Here in New Mexico, it's probably 2 years when it's all said and done before you can actually have a trial. So during this process, the court may decide to schedule this case, and either party can request that the court schedule the case and put deadlines saying, okay, the discovery needs to be completed by a certain date. If you want to have an expert testify, you need to designate that person as an expert by a certain date so that the other side can take the deposition of the expert. You know, setting deadlines for discovery can be good because then you know what you're dealing with, what you need to accomplish by a certain date. So the parties can ask for this schedule, or the court may just schedule the case on its own. And during this period, you have to make a decision. You know, do you want to have a jury? Do you want to just have a judge decide? There's some strategies that you'll talk over with your lawyer about that. If there's any documents that are going to be presented at the trial, you have to exchange those exhibits a couple weeks before the trial usually. And then you get set as well on a trial docket where you might get a specific date, or you may have what's called a trailing docket, where there's a 2-week period for these trials to happen, and you might be called in on the 7th day with a day or two notice. So there can be some anxiety there that, you know, you've got to hold a certain, you know, period of time open for this trial. Again, it can get expensive and it can be drawn out. So that's kind of a lawsuit and all the trappings of that and how it occurs and what goes on with it. Some of you may have been involved in a lawsuit before, so you kind of recognize maybe some of these things. But what can be done to minimize the risk of having a lawsuit? And that, you know, there's two sides to that, right? If you may be the one filing the lawsuit, you know, we're kind of focusing on, well, what's going to happen, or how can I keep from having someone sue me? So we'll kind of concentrate on that, but it kind of applies both ways. And some of the things I'm going to talk about can prevent you from being sued and can also help you so that you don't need to sue someone. So let's get into that a little bit. So if it's your practice to do business with another business, you know, verbally and that kind of thing, you know, like I said, it's leaving things up to a he said, she said. So you want to try to get as much in writing as you can. And if you say, okay, good, we're going to do that. We're going to do a contract. You know, how do I write it? What kinds of things do I want to put in there? You know, lawyers can definitely help you with that. But if you're going to do some of this on your own and you're going to write out exactly, you know, what it is, maybe it's a simple matter. I can't remember who said this, but rather than have it written so that it can be understood, you want to write it so that it can't be misunderstood. So much so sometimes even lawyers do this. They'll put an example in the contract so that there's no misunderstanding as to what exactly the terms of the contract are. So, you know, our one of the mottos of our firm is, you know, a little time spent up front can save you a lot down the road. That's what this is talking about here. You really want to take your time and write out exactly what it is that both parties to this agreement are going to do, and, you know, as far as payment and so forth, and what happens if there isn't payment. And you want to be smart about it. You want to put the time in up front. You know, you can spend a lot of time writing contracts and getting everything down, and you think it's so clear, but that, doesn't necessarily mean someone's not going to sue you. All you need is a filing fee, right? And you can go down to court and sue someone. But it does really alleviate the risk that you're going to lose the lawsuit as well. So you want to be careful. One of the things in writing these contracts, or when a lawyer writes them for you, the time is spent in really hammering down what these duties are going to be between you and the people on the other side of this agreement, and then other people that may be involved in whatever you're doing, whatever the activity is. Employees versus contractors. That's a big issue. People call a lot of times and they're not sure exactly what the difference is between employees and contractors. And a lot of times government agencies, the IRS says, well, we'll decide if this person is an independent contractor or not, or if that person is really an employee. So if you're getting into, you want to hire people to do certain things, but they're not employees, you don't want them to be employees, that's a consideration that you need to talk to a lawyer about, because there can be some ramifications for that. But those are contracts. If you hire an employee, there's legal duties to the employee, and they have duties back. Partners in partnerships, that's another big area of dispute in court. Partners get sideways with each other, and it's a result of possibly a misunderstanding as to what each partner was going to do or how they were going to get paid. So partnership agreements are very important. Let's say you're just going to partner with someone for one project. We don't want to have a partnership, a formal partnership, but we want to join together for one project. So that would be a joint venture agreement. Hey, these are the terms of our agreement for just this one project. And you can spell out the obligations and legal duties of the people involved that are coming together for one project. And then there's the typical situation, a business with the agreement between the business and the clients. How much is it going to cost? What am I going to do for you? Am I just going to do it and send you an invoice? What do we want to put on the invoice? If you don't pay this by a certain date, then interest accrues. If I have to sue you for this, for payment on this invoice, I want you're going to have to pay for my legal fees in doing so. These are all terms in the agreement between you and your customers that apply for that transaction. 99% of them go fine. You do whatever your service or product is, you get paid for it and you move on. But if you're just sending out purchase orders and or invoices, there is language that you can put in those documents that will help protect you on both sides, as well as perhaps alleviate the filing of a lawsuit based on that, because you're spelling things out in those documents. Same way with leases. If you've ever signed a commercial lease, they're 50 pages long. Well, because the lawyer for the landlord has written that all in favor of the landlord. So if you're on the receiving end of a lease, say from a landlord, you want to have your lawyer look at it to represent your side of it and look out for you. Same way with franchise agreements. The lawyers for the franchisors draft these agreements, and they're all in favor of the franchisor. So you need to have someone look at it from your standpoint. And it comes down to documenting things. And like I was saying at the very beginning of this regarding verbal contracts, if you can document things, even if you, God forbid, don't have a written contract, if you can send confirming emails, something that is written at the time that events are occurring, to confirm what was or was not said is also very helpful. Some of the things I recommend to clients are, keep record of phone calls. If you have a phone call with a customer or someone on the other side of a transaction, and you make some decisions, or you inform them of certain things, write it down, date it, and stick it in a file, because that can be very powerful if you end up in court, because it will show what was said at the time. In other words, it's not you 2 years later saying, I recall a phone call that I had. No, you pull out the sheet of paper and said, I wrote this down as soon as I hung up the phone with Jay, and he said this and I said that. That is very powerful, and the court looks at that as being very credible. So I recommend to clients, you may never need them, but in the course of business, if you can keep a record of phone calls, date, and who it was that you talked to and what was said, and incident reports if something happened on a project, or an event occurred that you think might be significant, write a little note, stick it in a file. And hiring employees, you've got to have records regarding reviews and timekeeping, to make sure that if something comes up down the road, you have been taking care of your documentation on these things, and you can pull that out, and you're going to be thankful that you did it at the time, even though at the time you think it's tedious. That can really alleviate, do some damage control if there's ever a lawsuit filed. And meetings, if you had meetings with groups of people to discuss a situation or an event. So I don't know who coined this phrase, but to be smart, be as specific as you can in these documents. Make it so that if there's some issues there that you've got to measure, you have that information in there. You want to have it be relevant as far as time is concerned. You don't want to just make a note and then there's no reference as to when it was made, or maybe who was on the phone call, that kind of thing. Those are the goals you want to strive for, that will help you mitigate this whole anxiety of having a lawsuit brought against you. And if it is brought against you, or if you are the one bringing the lawsuit, you're going to be prepared to either defend that lawsuit, or support the claims that you're making in the lawsuit, so that you can be successful. So you want to stack the deck in your favor. You want to hire a lawyer to help you prepare these documents ahead of time, so that you can really avoid the risk as much as possible. Like I said, anybody can file a lawsuit if they have the filing fee. Doesn't mean they're going to win, but there's a lot of cost and anxiety that goes into just being involved in a lawsuit. So it's a good thing to take those efforts up front. Another thing to consider whenever a lawsuit is filed is there insurance? Do you have insurance for that? And even if you think, I don't have insurance for that, always, and your lawyer will do this, always make sure that the insurance company is put on notice. Let them say there's no coverage. Sometimes they'll say, well, we'll defend this lawsuit for you, but we may pull the defense later, but at least we'll start off defending you. It's called a reservation of rights. They're reserving their rights to deny coverage, but in the meantime, they're going to provide a lawyer for you. And that can be a great cost savings for you. And then when you're talking, you're thinking, okay, I need to get a lawyer. What are the things that I want to make sure when I hire a lawyer? You want to consider costs. Some lawyers are more expensive than others. You want to find somebody that has experience in the area that's being addressed in the lawsuit. Do you want someone that's just going to be really aggressive, but isn't going to really listen to you so much? They're going to take control of everything and just let you know how it goes. Is that kind of what you want? Or do you want to be more involved? Do you want to, communicate with your lawyer a lot and join in the decision making? These are considerations that can affect the cost and can affect the amount of time you spend on this thing. So you want to hire someone that can meet your expectations. And you want to have somebody who knows your business. And a lot of times what I'll do is if someone is a new client and I really haven't dealt with that kind of business before, I'll sit down with them and say, explain your business to me. Tell me the ins and outs of it. What are the concerns that pop up the most in this kind of industry? And that's a good education process for you and your lawyer to go through if you're dealing with a lawyer that may not have the experience in your industry. So sorry about the technological problems there. We kind of rushed through this at the end, but as we're getting to the end, if anyone has any questions, I'll be glad to take them.
Thank you so much, Jay, and thank you everyone for being patient with the process as there was, kicking out of the internet and back. This was very helpful, lots of great information of how to be prepared, taking notes and being sure that, a lawsuit doesn't come along, but if it does, that you're prepared for it. So I don't know if there's any questions from the group. Feel free to put it in the chat. I don't see anything quite yet. And again, as a reminder, this will be, it's already recorded, but it will be posted on the YouTube channel within 24 hours.
And if anybody has any questions later, feel free to email me. I'll respond, the same day. So I know that things will come up. You'll think of things maybe tomorrow. Feel free to shoot me an email.
Thank you, Jay. I appreciate that. Well, I don't see any questions, so we really appreciate your time today. And everyone have a great afternoon. Thank you.
Thank you all.
Thank you. And Jay, if you can email that PowerPoint, or I don't know if Larry will, that way we can have it on in our shared drive. Okay?
Yeah, yes, will do. Thank you.
Thank you. Bye-bye.
Bye-bye.